Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. Today I'm going to be talking about privacy rights and freedom of expression in Canada. Specifically, I'm going to be talking about privacy and news reporting. This is a pretty big topic that could fill an entire course at both law school and journalism school, but I'm hoping to provide an overview of the significant laws and principles at play. I'm going to start with my usual disclaimer, though. This is intended to be a relatively general overview of the law for educational and informative purposes only. This is also a complicated area of the law with many nuances. I'll be talking about general rules, but there are always exceptions to those rules. If you have any specific legal questions, or if you're dealing with a situation yourself, you should seek qualified legal advice. All opinions expressed in this video and on this channel are mine and mine alone, and should not be attributed to my law firm or any of its clients. And of course, I'm only talking about the law in Canada. Privacy and internet law can vary significantly from jurisdiction to jurisdiction. Most of us would be familiar with the idea of freedom of expression or freedom of the press. In Canada, it's guaranteed in Section 2B of our Charter of Rights and Freedoms, under the heading of Fundamental Freedoms. This section reads, "Everyone has the following fundamental freedoms: freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication." In Canada, we regularly talk about freedom of expression, which is guaranteed to everyone, and it does include freedom of the press. In understanding how Section 2B works, we also have to understand that it's not absolute. The freedom of expression guarantee is subject to Section 1 of the Charter, which allows some limitations on Charter-guaranteed rights. Section 1 says, "The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society." So let's break that down. Charter-guaranteed rights can be subject only to reasonable limits that are prescribed by law that have to be demonstrably justified in a free and democratic society. It's always up to the government to justify these limitations. It's also important to note that the freedom of expression not only includes the right to express oneself, but the courts have found that it also includes a right to receive information. Limiting a journalist's right to report on something also limits the public's right to receive that reporting. The Supreme Court of Canada has given us the test for how to determine if an infringement of a charter right can be justified under Section 1. This is called the Oakes test, from a 1986 decision of the Supreme Court. This could also be its own law school course, but in summary, here it is. First, the limitation has to be prescribed by law. That's right from Section 1. It can be a federal or a provincial statute, it could be a regulation or a bylaw, but it can't be a whim of a state actor. It has to be rooted in the law. In some cases, the law could be so vague that it does not qualify as prescribed by law. Second, the objective of the law has to be pressing and substantial. The courts will not permit charter rights to be infringed for trivial objectives, so the law has to be for an important purpose. Third, the impact on the charter right has to be proportional, and this has three parts. First, the means chosen by the legislature to address these objectives must be rationally connected to the objective. In doing so, the measures need to minimally intrude on the impairment of the rights at issue. And finally, there must be proportionality between the infringement and the objective. This is a final balancing step. In order for an infringement of a charter right to be justified, the government has to satisfy all parts of this test. If it fails one part, the justification fails. The Oakes test is only used for limitations that are prescribed by law, and something different is done for the common law. The common law is that substantial portion of our laws that are judge-made, and sometimes a bit more fluid. Many of the privacy claims that I'll be talking about are common law, including intrusion upon seclusion and public disclosure of private facts. These aren't subject, strictly speaking, to the Charter. The Charter limits what governments can do, how our Parliament can legislate. The common law isn't generally a government imposing limits on what people can do, but usually regulate what legal claims one person can have against another. But the Supreme Court has said that the common law needs to evolve in line with charter principles and charter values. For example, in a 2009 case called Grant and Torstar, the Supreme Court of Canada said that the common law of defamation needed to include a defense of responsible communication on a matter of public interest to take into account freedom of expression. The protection of reputation was seen as an important value that had to be balanced against the important right of freedom of expression. So is the press subject to privacy statutes like the Personal Information Protection and Electronic Documents Act or the BC and Alberta Personal Information Protection Acts? Well, generally speaking, when engaged in journalism, they're not subject to those laws. To do otherwise would be unworkable. Journalists would have to get consent from politicians before reporting about them, whether it's favorable or critical. That would be a significant intrusion into freedom of expression. As a result, all three of these laws specifically exclude all collection, use, or disclosure of personal information that is exclusively for journalistic purposes. Here's what PIPEDA says. This part does not apply to any organization in respect of personal information that the organization collects, uses, or discloses for journalistic, artistic, or literary purposes, and does not collect, use, or disclose for any other purpose. Here's what Alberta's PIPA says. This act does not apply to the following: the collection, use, or disclosure of personal information other than employee personal information that is collected, used, or disclosed pursuant to Section 15, 18, or 21, if the collection, use, or disclosure, as the case may be, is for journalistic purposes and for no other purpose. But journalists are subject to the common law, like defamation, and could be subject to common law privacy claims. I'm not aware of any cases where a journalist has been sued for intrusion upon seclusion or public disclosure of embarrassing private facts in Canada. If one were to be sued, the court would have to take into account freedom of expression. So the public disclosure tort says one who gives publicity to a matter concerning the private life of another is subject to liability to the other for invasion of privacy if the matter publicized or the act of the publication would be highly offensive to a reasonable person and is not of legitimate concern to the public. Note that it includes the not of legitimate concern to the public part. So a lack of public interest is an important element of the tort, and proving public interest would overturn the claim. Intrusion upon seclusion is a tort. A person can sue another for an intentional or reckless intrusion into the private affairs of another without lawful justification, and that intrusion must be highly offensive to a reasonable person, causing distress, humiliation, or anguish. This tort was introduced into Canada in 2012 from the United States and may be subject to some refining. It may well be that a court would have to read in the public interest factors that exist in the public disclosure tort in order to be consistent with the freedom of expression right in a case involving legitimate news reporting. Freedom of expression also includes the information gathering stage of reporting. Now, you may have noticed that public interest came up in my discussion of the defamation defense created and granted Torstar, and also in the public disclosure tort. Public interest in reporting is important. Some provinces, like British Columbia, have statutory torts of invasion of privacy. They also use public interest to provide a defense. Here's the wording from BC. It is a tort actionable without proof of damage for a person willfully and without a claim of right to violate the privacy of another. It then says the nature and degree of privacy to which a person is entitled in a situation or in relation to a matter is that which is reasonable in the circumstances, giving due regard to the lawful interests of others. That could include news reporting. Third, it says, in determining whether the act or conduct of a person is a violation of another's privacy, regard must be given to the nature, incidence, and occasion of the act or conduct, and to any domestic or other relationship between the parties. This last part would very likely take into account whether the intrusion were done by a journalist pursuing a story in the public interest. This statute also specifically includes a defense for publications in the public interest or comment on a matter of public interest. But it is notable that this only extends to the publication and not the collection of information leading to the publication. We also have criminal laws that are designed to protect privacy. For example, we have a wiretapping law that makes it an offense to intercept a private communication. It does not include a public interest defense, and I suppose it could be challenged if a reporter was engaged in wiretapping or eavesdropping as part of a story. But just because it could be challenged doesn't mean that it would necessarily be successful. It may well be that a court would say that any restriction on freedom of expression is justified, and everyone's interest in being free from having their conversations overheard or phones tapped outweighs any impact on freedom of expression. We also have an offense of voyeurism, which includes a public good defense, which reads, "No person shall be convicted of an offense under this section if the acts that are alleged to constitute the offense serve the public good and do not extend beyond what serves the public good." It's hard to imagine a hypothetical scenario where a member of the press may be engaged in voyeurism and to use the public good defense, but it's there. And the legitimate information of the public on a matter of public interest would arguably be for the public good. In Canada, freedom of expression and freedom of the press are important values. They're rights that are baked into our Constitution, and all laws in Canada that affect expression or the ability of the media to do their jobs would have to be justified. This, of course, includes privacy laws, which may be engaged every time a reporter is looking into the private affairs or the private life of a subject. Thankfully, to take account of freedom of the press, journalists and journalistic purposes are specifically excluded from the application of our general privacy laws, which require individual consent for all collection, use, and disclosure of personal information. So what we're left with are the general rules in the common law and statutes that regulate problematic intrusions into privacy. On one hand, we have the general common law and statutes related to invasions of privacy. While they haven't been tested in Canada in the context of journalism, they do take freedom of the press into account. Similarly, we have laws that criminalize wiretapping and voyeurism, which could be subject to challenge related to possible impacts on freedom of the press. But these guardrails are likely justifiable under Section 1 of our Charter. Thank you very much for tuning in. If you found this to be of interest, you may also be interested in my video on recording and filming the police in public, which raises some similar charter issues. I'll link to it below. If you have any comments on this video or suggestions for topics you'd like to see discussed, please leave them in the comments below. I read and reply to all of them. And if you find this sort of content to be interesting or informative, please subscribe. And if you also click the bell, you'll be notified of new videos as they're posted. And if you know somebody who may be interested in this topic, feel free to share it with them. Thank you very much.